very good evening and a warm welcome to another episode on Law and Order. And today we are going to discuss on different aspects of apartment ownership law, a continuation from our program last week. And today we are going to focus on safety of a condominium property along with the powers and functions of a condominium management corporation and the condominium management authority. And once again, we are happy to welcome to Sri Lanka Rupavahini Corporation Channel I Studios, Mrs. Ajita Idirimana, attorney at law. She is a graduate from the University of Colombo with her LLB and also has completed her master's in law and business from Germany. It's a pleasure to have you here, madam.
Thank you. I'm happy to be here once again.
So, madam, continuing from our discussion last week, we discussed about what a buyer should be aware of and what a seller should, or what a developer should be aware of when investing in a condominium property. And along with that, we discussed on two major entities, and one is a condominium management corporation, and also the second the entity is the condominium management authority. So let me first ask you, madam, what is a condominium management corporation?
Okay, a condominium management corporation of a condominium property is the entity which is entrusted to maintain, manage and administer the common elements of a condominium property. Like how it was explained last time, the common elements are all those areas which do not get caught to a condominium unit. So if you take away the condominium units, the rest like the swimming pools, corridors, lifts, playgrounds, everything would be common elements. So common elements are managed by this entity called management corporation. Now that management corporation also has a name. Now this condominium project would be of course depicted in a condominium plan. Either it's a provisional condominium plan, semi-condominium plan or a completed condominium plan. In this particular instance, we are talking about a completed condominium property. Now the condominium plan, let's say, has the number condominium plan number 1, 2, 3, 4. Then the management corporation would be called management corporation condominium plan number 1, 2, 3, 4. That's how you identify and connect the management corporation to the condominium plan. Now this management corporation has members. It's similar to a board of directors, a company which has members. So now the members are all those unit owners. So then the management corporation in itself cannot administer and manage and maintain the common elements. So the Act has created an opportunity for a council to be established. Now once the management corporation, let's say the deed of declaration is registered, then the management corporation comes into existence upon registration. 3 months from that date, the condominium management authority would convene the first annual general meeting. At this, the CMA would be the convener only. During this first annual general meeting, a council is appointed from those unit owners who have the time, the expertise and the knowledge to be in a council. So because you really need specialized knowledge, and then the council would thereafter engage in, like a board of directors of a company, would attend to all the matters. So many things that has to be done, look into the aspect of cleaning, the mechanical maintenance, all that will be done by the council either on its own, or the council will appoint a managing agent under a management agreement to attend to this task.
And also when we talk about, you spoke about the condominium management authority, what powers does it have?
Condominium management authority is the supervisory body of all condominium properties.
And it's a state body.
It's a statutory body which has been established under the Common Amenities Board Act. Now it's called Condominium Management Authority Act. And it looks into various aspects. The powers are vast and the powers are given in this statute. So when people have problems, or actually more than that, when at the time of registering a condominium property, as I told you, the deed of declaration has to be submitted for registration. Now, along with this deed of declaration, there are series of documents that has to be annexed. One of which is the CMA certificate, Condominium Management Authority certificate. So, Condominium Management Authority primarily issues this certificate. The certificate would confirm that the common elements are adequate for this particular condominium property, and there are proper common amenities for the benefit of the unit owners. So, having looked into all these matters, of course, the Condominium Management Authority asks for various documents, and when they are satisfied, they issue the CMA certificate. So, apart from that, then there are also other matters which people refer and to the CMA and seek their assistance. That is, in most cases, disputes. Disputes arise between developers and prospective buyers, between unit owners and the management corporation. So, in the first instance, people refer to the Condominium Management Authority.
And also, what powers does the Condominium Management Authority have when governing, when supervising a condominium property?
Yeah, the powers are given in the Common Amenities Board law, which is called the Condominium Management Authority Act. Now, in most cases, there are unauthorized constructions where people try to expand the unit into the common elements, do various things which they should not do, because the boundaries of the unit are very clearly given in the condominium plan. So, when such things happen and when it is reported to the CMA, the Condominium Management Authority, after proper investigation, has the power to demolish such unauthorized constructions. And also, as I told you, for dispute resolution, the CMA can give an order. Either the party would accept it, or if they do not accept, they would seek a writ in a court of appeal. So, the powers are vast, and they also recently in 2017 issued regulations which compelled developers to do certain things. Of course, more can be done. Yeah.
And also, now in the recent past, there has been a wide public discussion about the necessity for ensuring safety in buildings, especially in multi-story buildings, because there were certain instances where certain multi-story buildings have collapsed, which caused loss of property and loss of lives. And there have been instances where elevators have collapsed. There have been instances where proper safety standards have been ignored, proper fire standards have been ignored in buildings. So, when we talk about a condominium property, a residence where people live, safety is paramount, and no buyer of a condominium parcel would like to put their lives at risk, especially at least in their home. So, in that aspect, what regulations are in place, or what does the government do, or what does the Condominium Management Authority do to ensure the safety of a condominium property, a condominium unit, or the entire building?
Yeah, this is a very good question. Last time I think I explained that it's absolutely necessary that the developer has a approved building plan before they start selling units. But in most cases in our country that is not happening because it has not been made mandatory. And also the provisional condominium registration, as we discussed last time, if a developer embarks on a condominium project, they should necessarily try to register the provisional condominium plan so that the unit as a subject matter can be created. Otherwise, it will be like registering sales agreements on the mainland, and when you go to a land registry to check on title, you find hundreds of such sales agreements registered one on top of the other. Now, when we talk about the safety aspect, if the development project has a approved building plan and consequently has been given a development permit, then that means the authority in urban areas, it will be the UDA, has checked into all the requirements. The title is there, whether of course if it's the sewerage and water line connections clearances have been obtained, and if it's a multi-story building, whether the soil certificate has been obtained, and if it is in a traffic congested area, when the traffic assessment plan has been done, and there is proper road width and also the height between floors, whether there is adequate ventilation of the unit. So, having checked all that, only will they approve the development plan. So, these are things which the government has done and made it actually, even though the government has done this, people still, they are not aware of it. They would put down their money for a project which doesn't have approved development plan. Now, the other most important matter is the fire risk. We are now talking about early into 1973, when this first statute was enacted, there was hardly any subdivided building of more than 5 stories. But now we have multi-story buildings going up to 60 floors. So, location wise, it will be absolutely nice if you can buy such a unit in a nice location where all the facilities, the commercial area, everything is there. But then one must think, is the fire aspect, fire risk properly addressed? Now, when I talk about the building plan, when I say that the UDA would give approval for such a plan, the UDA also would check the fire aspect, whether the regulations as given by the fire department has been complied with in such a project, or whether they will comply, where the area of the unit is concerned, where the fire escapes are concerned, whether there is adequate area for the people to, the exits other than the lift, all those will be checked before they give the approval. So, if and also in a multi-story building especially, there must be sprinklers, smoke alarms, then the fire extinguishers must be there. So, if all those are available, then only will this approval for the building plan be given. So, if people go ahead and enter into sales agreements where without checking those other important matters, then they are facing a risk. As you said, buildings are collapsing. Then sometimes, I must say, this is an interesting thing. I have come to know people who have been given approval, developer who has been given approval, let's say for 6-7 story building, subsequently having got approval, put another additional 2 floors. Now, that's a real risk, because when they did the soil investigation, probably that wouldn't the ground would not withstand the high volume. So, people tend to do things just for the sake of money, but the prospective purchaser must be cautioned that all these things are absolutely necessary to look into before you move into a multi-story building.
And also, when we talk about safety, before building, of course, we spoke about that you need to, get approvals prior to building. And what about maintaining these safety standards after it has been completed? Because once an apartment unit is completed, it will stay on, and there are certain apartment units which are 30, 40 years old. So, what authority ensures that these safety standards are well maintained, regulated, that the lifts are serviced on time, that the fire extinguishers are replaced on time? What authority looks into this? And if you're an apartment owner, if an apartment owner is viewing this, and if you think that if your apartment lacks certain safety standards, what measures can he or she take?
Yeah. In most cases, prospective unit owner or a person living in a condominium property would not know about the fire aspect. If they feel that everything is properly looked into, they would be happy. But then the fire department's regulations should be addressed all the time. I mean, they must, as you said, ensure that the fire sprinklers are working properly, the fire alarm works properly, the fire extinguishers works properly, and there is adequate storage of water to be used in the case of a fire. So, but we don't have a kind of a compulsory supervision which management corporations have to do, like once in 2 years or once a year, where authorities send someone to check whether these things are done. It's not happening. But they are, in terms of the fire regulations, as far as I know, once in 3 years in high-rise buildings, they have, because there's so much of public gatherings, they have to see that they have addressed all these issues, and also like they have checked whether there is additional exit for the building, and they have to report to the authority. As far as I know, I don't know whether the people are complying with this, but this is an important matter which I would say condominium management authority, being the supervisory body, could perhaps enact regulations so that people would be compelled, management corporation and its council will be compelled to observe.
And also, my next question comes about usually when it comes to land, we are well aware that there are many disputes. So, what kind of disputes arise usually when it comes to condominium property? From your practice in the area of condominium property, what disputes have you practically witnessed among litigants or among people who own condominium property?
Okay, now disputes can be categorized into 2 or 3 different categories. There are disputes between unit owners. In most cases, because maybe due to now in a condominium property, all unit owners must ensure that they are not disturbing the other party, and they have to, there are certain statutory bylaws, and also condominium property, the developer at the beginning itself would have issued other bylaws regarding how to live in a condominium property, that you should not disturb others, you should not bring disrepute to the building, and usage of the common amenities, so on and so forth. Now, if a unit owner has breached any of these bylaws, then another unit owner might feel compelled to report to the management corporation, and if there is no solution within the condominium property, they would lodge a complaint with the condominium management authority. So those are disputes between unit owners. Now there can be disputes between the management corporation and a unit owner. The most common occurrence is when the unit owner fails to pay the service charge. Now the service charge is actually an important payment that the unit owner has to pay, because without that money that gets accumulated in the management fund, it's very difficult to maintain and manage the common elements. And under the 2003 Act, the management corporation is vested with a lot of powers. That is, now if they fail to pay the electricity payment or the water connection payment, the management corporation has become a licensee for this water board and the electricity CEB. So using the powers that has been given under the 2003 Act, the management corporation can disconnect electricity, can disconnect water services. And also the service charge has become a problem, because the 1945 Act actually has given a lot of powers. That is, if you go on failing to pay your service charge, the Act also has provision for the management corporation to sell the unit and use that money to settle the dues to the management corporation. But that has not happened so far in our country. But of course there are very strict procedures to follow before one embarks on that. So there are these disputes between management corporation and the unit owner. Then the other one, of course, is between the developer and the prospective buyer. Those are quite a lot of disputes, because sometimes having entered into a sales agreement, the prospective buyer would find that the building has not yet been completed. That's quite often it happens. Sometimes in the sales agreement, the estimated completion date is not given, and then the developer, for various reasons, fail to complete on the due date. So then when such problems crop up, also the unit owner, the prospective purchaser would report to the condominium management authority. So there, and I have seen another very interesting matter where developer had registered the provisional condominium property. Now in a provisional condominium property, the units are just provisional only. The COC has not yet been given. That very clearly says you can only mortgage, that is the developer can mortgage the land, and the developer can enter into pre-sales on sales agreements. But in this particular project, I've seen the developer had sold units under deeds of transfer to the purchasers of the units. He had got the entire sum of money, and interestingly, the land registry has recorded that the deed of transfer without refusing registration. The land registry had accepted and recorded it in that provisional folio. So once again, we have in this particular case seen a breach by the developer. Statutory obligations have been breached because you can't do that, and the land registry has failed to appreciate that this is not a proper deed of transfer and given title to the unit. So now I have seen these people are trying to overcome this problem. So there are so many very interesting matters that I have come upon in my career relating to disputes.
And also, now as you said, condominium property is a vastly developing area of law, and there have been many amendments to the apartment ownership law which was brought in 1973. And as a practitioner and as a researcher into different aspects of condominium property law, what law reform should be made to make it a more holistic piece of legislation?
Yeah, now the last amendment to the law was in 2003. So now we are in 2020. So quite a lot of things have happened since then. Now what we see are multi-story buildings of 60 stories and more. So what was applicable in 2003 is not the same now. There are more problems, and there are more the clauses, the provisions of the apartment ownership law as given in 2003 needs to be obviously amended to address the present situation in the country. In what I would suggest is primarily we have to see that the provisional condominium registration, which is covered in the 2003 Act, should be made mandatory, because then people would have a proper subject matter for which they are giving their money. Now there are financial institutions which of course give funding for prospective purchasers. Financially they can't execute mortgage bonds, so what they do is they enter into tripartite agreements with this purchaser and the developer, so that if the purchaser fails to pay the loan interest and installment, the bank, the financial institution, steps into the role of the purchaser. So if the project is not properly registered, what the financial institution gets is nothing better than what the purchaser had. So therefore, I think if we want to have developed the condominium regime and have more condominium properties where people feel confident that they have proper title, they won't have any problems, then primarily I think provisional condominium registration must be made mandatory. Then as I told you, we see people just parting with their hard-earned money, not knowing what kind of a project am I getting into. Now in Western countries, especially in the USA, it is mandatory to issue a disclosure notice where the developer would list all the features of the condominium property, the sale price, the description of the unit, what amenities are given, what is the budget for the first year, what would be the service charge during the first year, who would be the managing agent, and what are the common amenities given, do we have to pay extra for that. Everything would be given in this disclosure statement, and that is registered with the relevant authority. So it's a public document. But in our country, there's no such thing. Anybody who embarks on a project would just give the sales agreement. Then it's up to the lawyer to check this, and if the lawyer doesn't do that, or if the buyer doesn't get the relevant information, he or she is at a loss. So I would say that we have to have some kind of a document like a disclosure statement, which is made mandatory before a development project, and the developer is allowed to start pre-selling. It's like a prospectus in a share issue, because you give all the details. And then also I feel now when we consider share values, in our country currently the survey only takes into account the square feet area of a unit as against the total square feet area of a condominium property. But now when a condominium property is demolished, because there are instances when that happens, the common elements are considered the residue, and the unit owner is given that residue based only on the share value. So if a unit owner entitlement is considered only on the basis of the square area of the unit, I think it's disadvantageous for the unit owner, because some unit owners pay on a higher level pays more than a unit owner on a ground level, and then there are they would use more service charges, I mean the utilities for the lifts and things like that. So I feel that they must take into account a formula to determine the share value. So, and that's also important. There are many other things I feel that the law reform should take into consideration.
Yes, madam. And with that question, we would like to end today's episode on law and order. And on behalf of Sri Lanka Rupavahini Corporation and its administration, we would like to thank Dr. Attorney at Law Ajitha Adrimana for gracing this discussion today and for sharing your wealth of knowledge, particularly in the field of condominium property law or apartment ownership law. And we hope to meet you once again on another episode of Law and Order. And we wish our viewers a very pleasant night.